Members, thank you for coming. We have a quorum. Now let us invite the administration and also the deputations to come in. There are 4 deputations and individuals who have registered to attend the meeting today. First of all, I'd like to thank the administration for coming. We are awaiting other people, deputations, who are coming in. First of all, I'd like to thank the deputations and individuals for attending the meeting. I'd like to remind you that Channel 0 is the floor, Channel 1 is Cantonese, Channel 2 is English, Channel 3 is Putonghua.
Translation, Channel 1 is Cantonese, Channel 2 is English, and Channel 3 is Putonghua.
I'd like to thank you for coming. Everyone will have 5 minutes to speak. I'd like to remind you that when you speak, you will not be protected and exempted under the Legislative Council Powers and Privileges Ordinance. And also, inside the complex here, whether you're attending the meeting or even if you are in the public gallery, please take note of the note for members of the public attending meetings in conference rooms or observing meetings in public galleries in the Legislative Council complex. If you do have a script or a submission, please leave a copy with the Secretariat. So first, the first deputation from the Lion Rock Institute, Mr. Andrew Shen. Thank you, Chairman. The Lion Rock Institute, actually at the time when the competition ordinance was enacted, should be the one organization that was in the greatest opposition to it. We pointed out so many problems. For example, how do you define competition? And also, why is it that the same department would be arresting and then adjudicating people? I understand there were many voices saying that the division of power should actually become a cooperation of power, and then actually this has been embodied in this competition ordinance. At this stage, I can say that the government under Donald Tsang enacted the ordinance, and somebody said that at the Bills Committee, the Lion Rock Institute staged a filibuster. It was not true. There is a lot of debate about filibuster lately in the community, but in fact we have been asking questions. And I can say this law is fraught with imperfections. Some people say the Lion Rock Institute is radical, that we are unreasonable. But then, before the ordinance was actually in action, the administration is already proposing a bill to amend the ordinance to get more powers in order to further delineate the implementation of the ordinance. I would ask the question, some of the members then were not really up to par. They just wanted a competition law. And so they forced through this ordinance, which is really fraught with irregularities. And now you are trying to make up for what you did wrong. The Lion Rock Institute thinks that when this was drafted, I believe you deliberately left many gaps. Since there are so many gaps, then you would not be taken to task by other people. I remember at that time when there was a public hearing on the competition bill, many deputations would come, and today we only have 4. I believe this is because people would think that the amendment bill is just technical. I think the administration's tactics are effective. You deliberately left the gaps, and then now you seek to fill the gaps, and then there will be no more voices of opposition. The Lyrak Institute, however, is firm in our stance, but of course this is now a fait accompli, and Hong Kong people are just stumped with this competition ordinance. A few weeks ago I read this report. When the competition law was passed, many people cited the supermarket business as an exemplar of monopoly. But then the law has reacted slowly to the situation in the market. They did not see this store 759. At that time, there were just a dozen such stores, and I was a financial commentator then. And as you know now, it has expanded to 60 or 70% of the total number of stores of Welcome and Park and Shop. And before the competition law, it is already chasing right behind the 2 supermarket chains. And then the news report had it that the 759 store would import directly from Japanese exporters, and the exporters thanked them for standing by Japan during the Fukushima incident. And so the exporters would not be supplying to other supermarkets in Hong Kong. And the news report actually said that the Japanese were grateful. And so there was this discrimination against Hong Kong supermarkets or retailers who were actually willing to pay a higher price. Now, I would ask you, under this competition law, this naturally occurring supermarket competitor, would it be caught under this ordinance? I'm sure the first one would be 759 store. Thank you very much, Ms. Amanda QUEIROZ.
I'd please like to ask you to imagine this scenario. You're almost drowning in the sea, and out of a sudden, a boat approximates you. And however, those who appear to save you are members of a tribe known to eat human flesh. Would you accept their help, but maybe take the risk to be eaten later, or rather deny their help and try to save yourself in the sea with the chances of drowning? This is exactly the paradox business on the free market economy of Hong Kong face when they are presented with laws such as the amendments to the competition ordinance to give more powers to the competition tribunal. This is because one may ask, how will the companies will know that this small intervention of the government to maximize fairness on the market are in fact not only for the protection of this business and shall not be for other interventions? Isn't it not risky to give the government so much influence over our market economy? The amendment of the competition ordinance starts by declaring a bill to amend the competition ordinance to give the competition tribunal certain specific powers and provide for certain operational matters that are necessary to ensure proper functioning of the competition tribunal and to make miscellaneous amendments to other ordinances. There are many issues with this statement because first, giving specific powers to the competition tribunal is only one step to a journey that will lead to more intervention in the economy by the state. And second, in what sense necessary matters are so-called necessary? Who are they for? Are they really on the interest of the public and businesses of Hong Kong, or in the interest of the Hong Kong government in increasing its powers over economic affairs? Now, The amendment to the competition ordinance, which already puts many restrictions on the free market economy, not only a bad step economically, but politically. Cannot be free if they don't have a free economy, if their aims are not pursued and their ideas are denied in this economy. To protect Hong Kong people and their businesses, this amendment to the ordinance should be stopped. Thank you for your time and consideration.
好啊，下一位啊，黃貴先生，黃貴生先生。
Mr. Wong, please. Mr. Wong Kai-sang. Yes, why am I coming up even for this particular ordinance? I'm working in the Jockey Club. In 2003, the Legislative Council had given to the Jockey Club the operation of the football betting. Any competition needs a competitor, but on the other hand, competition had been relinquished in our case. Why do I say that? In the 1970s, horse racing had been made professional. That was in protection of the staff. And this year marks the 40th year of Telebet. And at a time, the neighboring port city had opened up for gambling in terms of horse racing. And then there was a competition. And then in 2003, Mr. Cully, as a chairman, said that, yes, let us start with soccer betting. And indeed, that had increased the number of staff who are working at the Jockey Club. But unfortunately, that has not been the case in the very recently. Well, not a lot of people are working here. Everybody is criticizing. It seems that competition had been relinquished and the betting pool and betting money had come down significantly. We are worried. Would it be again in the 2002, 2003 situation where there was insufficient work and the salaries had to be, our income had to be slashed? Actually, I have a booklet here. This marks the 10th anniversary of soccer betting. I will show you this book later on. Well, actually, I do not know how long I will last because we have been working day and night. We have to work for the... Well, Mr. Wong, you have to speak to the topic. We are really talking about competition law here. Well, indeed, because as we amend the competition ordinance, the Lecho had given them a license, but they are not doing the business. Hold on, we are really talking about the tribunal, not about the competition activities as such. Well, what I'm trying to say that you have to amend the law. At the night time, there are just a few dozens people. The course betting is getting rampant, and it is a big undercutting of the business that we have. In Macau, gambling activities as well. And every day you see, even on the television or media, that there is talk of combating, of course, betting. I think we have to amend the ordinance in response to this. I am referring to a document which was tabled at the LegCo CB-21174-12-1301. I'm sorry, you're not speaking to topic. I'm sorry, I have to stop you here. Mr. Lo Puyin of the Hong Kong Bar Association, please. Yes, Mr. Chair. Yes, the stakeholders' consultation and leading to some of the changes to this proposed amendment of the ordinance. We have participated in that, and we are in support of some of the content. And this has been made available to members. 1695-131402. You can look at that particular appendix there. The opinion is expressed therein. And I've looked at the legal advisor's proposed amendments to the wording, As for the Bar Association for coming up today to this meeting, we are here to say that for this draft, for some of the proposals raised in this amendment, we have the following points to make. First of all, if we look at Clause 4 concerning the not allowed to leave the territory. In fact, there had been certain communication even beforehand between the Bar Association and the authorities as to why the tribunal is given that particular right. And also, we have made it clear that what our concern, that is a Bar Association's concern, had been. Our concern is that if the tribunal is to be able to have this power of issuing this bar from leaving the territory, then of course this will have to entail an appellant right to the Court of Hong Kong. And I see that the administration, in drafting this particular ordinance, had already considered this point of ours. A second point that I would like to raise here has to do with Clause 6. And basically, this is to allow the registrar of the tribunal to enforce and chase for payment of penalty or fine. And the tribunal would have to first confirm the fine, and then the registrar will try to enforce that payment or fine. I think it would have to be more clear as to who will be responsible for the enforcement of the payment of that penalty. Would it be the DOJ? And it further goes on to the judiciary duties in Section 7 of the registrar. The Bar Association had raised the opinion that we can refer to the UK Competition Tribunal Clause 62, and in the court's guidelines or practice, it is made clear as to what rights or powers can only be wielded by the members of the tribunal or the chairman of the tribunal, and which powers will be in the terms of reference of the registrar under authorization by the chairman of the tribunal. And the judiciary had responded to our opinion to the above effect that this view will be considered. And we go on to Clause 10, that there will be a 152 bracket A added to this particular section. And the details are not gone into yet. I would like to have the administration go into further details and to see whether this will be written into the court conventions and practice. Thank you very much for coming up to this meeting and giving us your very valuable view. Would the administration please give a succinct response, please? Thank you very much. First of all, I would like to thank the Lecture for arranging this meeting for us to meet with the deputations and to hear their views concerning the Competition Amendment Bill. If I can make some preliminary responses to the points raised just now. First of all, the purpose of the Competition Amendment Bill is to amend the Competition Bill and to list very clearly the Competition Tribunal terms of reference so as to provide a clear and clearer legal basis for the operation of the tribunal in the future. In fact, the terms of reference of the tribunal and the members of the tribunal refer to the CFI, that is the Court of First Instance procedures and practice. And we believe that this will be important for the smooth operation of the Competition Tribunal in the future. And these amendments would not change the competition terms or the operation of the Competition Commission. And in our preparation work, the judiciary and the administration had been working very closely together in preparation for this very important law. And the tribunal is being helped by the judiciary with directions and certain opinions and preparatory work given to its setup and also its operation. This amendment is important for the smooth operation of the Competition Tribunal, and it should be passed before the actual implementation of the competition bill in full. The Bar Association had mentioned just now that there are certain proposals they want to make concerning certain clauses. First of all, on the injunction. First of all, we understand that the Bar Association's concern, we would want to point out that according to this particular bill, the Court of First Instance can be relied upon, its procedures and its practices, and the members of the tribunal are also members of the Court of First Instance, so they would know the points and procedures that are and safeguards that are to be followed in their deliberations. And the tribunal will be utilizing the powers accordingly. And it was mentioned the concerns concern the implementation of clauses 6 and 10. There will be certain supplements from the administration later on. I would like to ask the judiciary, the DOJ, to discuss some of the details concerning the implementation. Thank you very much for the Bar Association's views. First of all, in response to Clause 6, there are certain enforcements of fines or payments of penalty. In fact, we have referred to the HCO, the High Court Ordinance, Section 38(1), and these will be carried out by the court and not by the DOJ in response to the question. And also, in previous discussions, the Bar Association had mentioned to us that the UK competition clause, competition law, and certain clauses therein can be referred to specify where what powers should be wielded by the judges and what should be within the terms of reference of the tribunal. We do not have such details. These will be in the practice and guidelines that we are drafting, in the process of drafting now. We will be going to the Bar Association and other bodies for consultation at a later stage. In fact, the work is really interlocutory applications, and it is much like the inner court work of the judges. And we believe that in the future for the tribunal, this will also the demarcation of division of work between the tribunal and also the judges. We will be going to the Bar Association for consultation in the future. Mr. Albert Ho, please. Yes, Mr. Chairman, I would like to put a question here. In other ordinances, there are similar tribunals set up as well. For the securities ordinance, for instance, I would like to ask the Market Misconduct Tribunal, is that the same First of all, does it also come under the High Court ordinance? And would it also be barristers representing the parties in the tribunal?
Who will take the question, please? From what I understand, Chairman, Mr. Albert Ho mentioned the Market Misconduct Tribunal. The status is not the same as the Competition Tribunal. The Competition Tribunal is a higher court of record. It is at a par with the CFI, and the judiciary can certainly add to what I'm going to say. The MMT actually is not part of the judiciary, actually. Ms. Jim? Let me say something. In the judiciary, we have many different tribunals, but then the one that you quoted just did not belong to the judiciary. It is not a court. In our eyes, it is an administrative organ. It is a statutory organ, of course. So it is not the same as what we are talking about. In the judiciary, there are other tribunals like the Lands Tribunal, the Labor Tribunal, but other tribunals are not at the same level of the Competition Tribunal. The Competition Tribunal would enjoy the highest status in terms of tribunals. Now here we have deputations. If you have questions, please ask the deputations first, so they can choose to retire early if they are otherwise engaged, and then we can still have a conversation with the administration. Now I have a question for Mr. Low from the Hong Kong BA, please. I find it a little strange that this competition ordinance and the SFO, which seek to tackle financial orders, they are here to help us maintain business and financial order, and each side has a tribunal. If that court is not a court of record, why is this one a court of record? And from what you know, if that tribunal is not part of the judiciary, then there would be less restriction or even no restriction for the rights of audience. Whether it be an advocate or a solicitor, there is no limit to the rights of audience. Is that right? And do you think there should be such a comparison made? Do you think the Competition Tribunal should be a court of record, Mr. Low? Let me reply to Mr. Ho. First of all, the Competition Tribunal is a court. It is a higher court of record. It is specified at this level, and this has been entrenched in the competition ordinance. Mr. Ho is concerned about the right of audience of legal practitioners. A tribunal set up by law, whether it be part of the judiciary, and during the legislative process, the legislature can decide whether or not legal representatives are allowed, and indeed what type of legal representatives are allowed. In the judiciary, if you look at the Labor Tribunal and the Small Claims Tribunal, in fact, no lawyers are allowed to appear in those tribunals. And also, the general status in courts is that solicitors and barristers can both appear in court, but then in certain legal procedures, only barristers are allowed. And also, even up to now, only lawyers with the higher right of audience can appear in certain courts. So to a very large extent, it's up to the legislature to come to a view whether or not there should be any limitation at all to rights of audience of lawyers. And as for the Market Misconduct Tribunal, I looked at the relevant ordinance, and that is the Securities and Futures Ordinance, how the MMT is positioned. Actually, at the time of legislation and also after that, when there was a case about the positioning of the MMT and whether it has anything to do with the division of powers, it was decided by the judges that the MMT is within the administrative organ, and it only has a function or a judiciary function, but then it is still administrative organ. Therefore, we cannot draw a comparison between those two. Thank you. I have no follow-up. No follow-up from me. But I have other questions for the administration later. Other members, would you like to ask any questions of the deputations? If not, I'd like to thank the deputations for coming. Thank you for coming to the Bills Committee. Thank you. You are welcome to stay, and if you have further views, please let us know. Let us continue. Now we'll have a meeting with the administration. Now let us attend to paper CB bracket 1, 1695, bracket 01 and bracket 02. Also, before the meeting today, the administration also tabled a paper which has not been given a serial number. If the administration is willing, they can address both papers now. DS. Chairman, with regard to questions raised by members at the meeting of the 12th of June 2014, we submitted the written response before the meeting. Now I'll let you know our response. The members would like to know the views of the Hong Kong Bar Association and the Law Society of Hong Kong. In the annex to the paper, we have already included the views of the two legal bodies on the proposed legislative amendments to the competition ordinance. That is a full report. Second point, the general powers of the tribunal. In paras 3 and 4, we have responded to members' questions raised. You asked about the specific powers to be conferred on the tribunal and whether that would affect the general powers in the CO. Now, actually, the CO uses a general approach to express the powers of the tribunal. But then, these particular clauses should be regarded as supplementary to the existing provisions which set out the general powers of the tribunal rather than to limit their generality. Therefore, we believe the new clauses should not have any limit or effect on the general powers of the tribunal. In para 5, we quoted the Lands Tribunal Ordinance, which adopts the same approach. In Section 12b, for example, it says that it actually adopts a similar approach as in the present ordinance. The third point, order prohibiting departure from Hong Kong. In paras 6 and 7 of the paper, we explain the proposed sections 151A, 151B, and 151C about the order prohibiting departure from Hong Kong, and that is how it would apply. In fact, this is modeled on Section 21B of the HCO. Our policy intent is that the tribunal would follow the existing practice of the CFI with regard to the operation of the same section of the HCO in the exercise of the tribunal's powers. After looking at case authorities in a general situation, the person associated with the company, for example, director or shareholder, they will not be affected by the prohibition order under 151A. However, if this person associated with the company is also a party to the cause of action against the company, then he is joined as a defendant in the proceedings. Now, point 4, prohibition order under Section 21 of the HCO. This is covered in paras 8 to 11 of the procedural requirements of Section 21B of the HCO for members' reference. And we have stated here that this has to do with Order 44A of the Rules of the High Court, and it provides for detailed procedural requirements under Section 21B. Point 5, some members asked about the meaning of property in the proposed new Section 151A1B2. We consulted legal opinion, and we are of the view that the definition on property in the Interpretation and General Clauses Ordinance would apply to the CO, since it can include intangible and movable property. We believe that this should be able to cover intellectual property as well. This is my brief introduction of the paper, and I would welcome questions. Members. Legal advisor. No questions? Okay, you can continue. Can you now address the paper that has just been tabled before the meeting? Would you like to go through it? Yes, there is another paper, Chairman. This has to do with right of audience of the lawyers. May I defer to the judiciary, please? Ms. Zheng. Yes, Chairman. Last time, it was asked whether solicitors will be allowed to appear in the tribunal. In the paper, we have given an account in paras 2 and 3. As we said, the status of the tribunal is at a par with the CFI. And we also summarized what happened in 2009 and 2010. And at that time, members were discussing the Legal Practitioners Amendment Bill, and different views were considered, including those of the Bar Association and the Law Society. And also within the judiciary, the Chief Justice then said that the most important consideration about the right of audience was that in this adversarial style of procedures, we must have the highest quality of advocacy in the courts of Hong Kong. And that is, we must also have the highest quality of independent legal representation. And that is why in 2010 we have what we have now in the Legal Practitioners Ordinance. And the ordinance says that not all solicitors would be given the right of audience at the High Court. They would have to comply with Part 3B of the ordinance before they would be given the right of audience. In paras 8 to 12, we point out that since the CFI and the tribunal have many similarities between them, and the cases to be processed by the tribunal would be very much similar to business cases heard at the CFI in terms of nature and complexity. That is why we believe we should apply the same considerations of the CFI vis-à-vis right of audience to this tribunal. So the CFI and the tribunal will be in the same position, and the litigants will be able to make use of the same team of legal representatives at the two different courts.
In the provisions of the competition ordinance, it is already mentioned that there can be transfer between the CFI and the tribunal in part or in whole. And that is why, in our proposal, we believe that the legal representation should have attained a certain level before there can be audience in the tribunal. Thank you. Questions? If there are no questions, we can go to the clause-by-clause vetting. CB3 1314 and CB bracket 1 1591 1314. And the response from the administration, 1695 13-14 If you have no other questions, we can deal with these as we go along. Mr. Wu first. Yes, in the previous meeting, we have gone to clause 4. We can now continue. The fourth clause basically had included 151A, B, and C, and they are based on the High Court provisions. And basically, the CFI at the High Court able to provide certain prohibition order for the person concerned, the debtor concerned, to leave Hong Kong. And apart from expenses and penalties, there will be an enforcement of such payment of money or damages or penalties. If I can just go through these three clauses one by one. In the proposed additional 151A bracket 1, the tribunal may make an order prohibiting a person from leaving Hong Kong. In short, the prohibition order, A, to facilitate the enforcement or to secure the compliance of judgment or order against a person for payment of specified sum of money, a judgment or order against a person for payment of an amount to be assessed, or against a person requiring the person to deliver any property or perform any other act, or to facilitate the pursuance of civil claim for payment of money or damages. In 151A2, bracket 2 and bracket 3, well, basically, the tribunal must not make a prohibition order against a person under certain circumstances. And if such prohibition order is made against a person, that it must be satisfied that there is probable cause for believing that the person is about to leave Hong Kong, and because of the circumstance mentioned, satisfaction of the judgment or order concerned is likely to be obstructed or delayed. And in bracket 3 there, the tribunal must not make prohibition order against a person unless it is satisfied that there is probable cause for believing that there is a good cause of action. Or the person incurred the alleged liability being the subject of claim in Hong Kong while the person was present in Hong Kong. And 1515, the person on whose application a prohibition order is made must serve a copy of the prohibition order and a copy of any other order ancillary to the prohibition order on the Director of Immigration or the Commissioner of Police. And the person against whom the prohibition order is made, if the person can be found. And in this section, tribunal includes a registrar, senior deputy registrar, and deputy registrar of the tribunal. No questions here? We carry on to 151B. This is on duration and discharge of prohibition order and the extension or renewal situations. 151B1, prohibition order is valid for 1 month beginning on the date of the prohibition order unless extended or renewed under the section. And according to 151B2, the tribunal may, on application by a person on whose application a prohibition order is made, extend the prohibition order for a period that, in combination with the initial period and any other period of extension, does not exceed a total of 3 months. 151B3 and 4 specifies that the tribunal may, on application by a person on whose application a prohibition order is made, renew the prohibition order. A renewed prohibition order is valid for 1 month beginning on the date of renewal and may be extended under subsection 2. That is the extension of the prohibition order. So you're saying no more than 3 months? Yes, the extension of the order is no more than 3 months, but it will start counting again if there is an extension or renewal. I would like to know from the administration, for 151B, the new one, with the extension and the renewal, concerning renewal, are there any limit as to the number of times of renewal, once only or unlimited? And if the tribunal finds fit, can it be continually renewed with no limit? Thank you very much for the question. As in our written response, according to 151B3, the tribunal may, on application by a person on whose application a prohibition order is made, renew the prohibition order, as long as the conditions reached, the renewal, the times of renewal is not limited. And this is similar to the existing practice at the High Court. And there are certain safeguards. The tribunal will have to first satisfy that the relevant stipulations and the conditions are met, and also there can be an appeal to the appellant court. So there are certain safeguards. Questions from colleagues, please? None? Mr. Hu, please. 151B5. It basically satisfies that the reference to the initial period in subsection 2 is a reference to the period of 1 month mentioned in subsection 1 or 4. 6 and 7 specify that a person on whose application prohibition order is made must, as soon as reasonable possible after the prohibition order is no longer required, serve on the Director of Immigration a notice stating that fact and file with the registrar of the tribunal a copy of the notice mentioned in paragraph A. And these two notices will be filed, and for the latter date will be taken if the notice under subsection 6 is served and a copy of the notice under subsection is filed on the same date. 8 goes on to talk about the tribunal may, on application, discharge a prohibition order either absolutely or subject to any conditions that it thinks fit. Number 9 is the definition, prohibition order and tribunal. Mr. Chairman, 151B6, we have written to the administration. We notice that a person on whose application a prohibition order is made must, as soon as reasonably possible after prohibition order is no longer required, serve on the Director of Immigration notice stating that fact. But I'm looking at 151A5. It is slightly different again, in the sense that the prohibition order will have to be copied to the Director of Immigration and the Commissioner of Police. That is where the application had been made. But if we look at 151B6, it says where the prohibition order is no longer required, then only the Director of Immigration need to be served a notice stating that fact. Why is there such inconsistency? It is indeed for 1515 and 1516, the notice are different, because for 5A it is about the successful application of the prohibition order, and the copy will be made to the Director of Immigration as well as to the Commissioner of Police, because if there is anybody who tried to contravene this order and try to leave Hong Kong, then the frontline officers, including the police, will make an arrest of that person, and the police will have to refer to records to see whether there was a prohibition order, and that is why for 4 and 5 under 151A that the Director of Immigration and the Commissioner of Police be notified. But for 1516 scenario, where the probation order is no longer required, only the Director of Immigration is to be served the notice, because under such circumstance, the probation order is no longer required, and therefore the police will not need to provide any enforcement assistance. So the police will not have to be notified. The way we draft this is inconsistent with the High Court wording. Well, will the scenario arise where the police does not have a record of the probation order no longer being required and therefore make enforcement actions causing inconvenience? Yes, perhaps my colleague will respond to that. Well, we have communicated to the police and the immigration, and there are no such cases. In fact, once the debtor had been discharged, in fact, he'll be very happy, and he will inform the lawyer, and on his person, he will have a document from the judge to specify that from the tribunal to say that he is able or allowed to leave the territory. But even if that is the case, why not inform the police as well to make it very sure and clear? Well, we have learned from the High Court and the very experienced officers that there's not been any problems in the past, and therefore it is not therefore necessary. That is all. Any other follow-up? No. Mr. Wu, please do continue. Yes. 151C. This proposed addition 151C is on the contravention of prohibition order. According to 151C1, if the tribunal makes a prohibition order against a person and the person having been served a copy of the prohibition order or otherwise informed of its existence still attempts to leave Hong Kong in contravention of the prohibition order, the person may then be arrested by an immigration officer, police officer or bailiff of the tribunal. In bracket 2, a person arrested under subsection 1 must be brought before the tribunal before the expiry of the day after the day of arrest, and the tribunal may, under different circumstances, make an order discharging the person from arrest, either absolutely or subject to any conditions that it thinks fit, or, depending on the scenario, if the probation order is made under certain sections, make an order for the examination or imprisonment of the person. And in bracket 3, section 71 of the Interpretation and General Clauses Ordinance does not apply to subsection 2 because it is about the calculation of number of days. We do not make it applicable because we want to, as soon as possible, bring the person in front of the tribunal for judgment. And in bracket 4, the Director of Immigration is not liable for any failure to prevent a person against whom a prohibition order is made from leaving Hong Kong. As for the last one, bracket 5, in this section, prohibition order means an order made under section 151A, and the definition of the tribunal is also enshrined here. Questions, colleagues? No. Mr. Wu, please do continue. Mr. Chairman, we're now at clause 5. Here we are proposing to put in a new sections 153A and 153B, and they are based on the High Court Ordinance and 48 and 49. And basically, it is with regard to interest on debts and damages. Basically, the tribunal in the proceedings before the tribunal for the recovery of a debt or damages.
Under the competition ordinance, the tribunal can also make orders on such damages and costs, and these are in Schedule 3 of the ordinance. Even if the tribunal has the power to make a judgment on the damages, however, there are no specific provisions empowering the tribunal to make judgment on the interest on debts and damages. For the sake of clarity and consistency, we like to add in 153A and B so that there will be such specific powers. Chairman, if you allow me, I will now go into 153A and B. 153A, this will empower the tribunal to do this in proceedings whenever instituted before the tribunal for the recovery of a debt or damages. The tribunal may include in a sum for which judgment is given simple interest on. And bracket 1 tells you how simple interest is calculated. A, all or part of the sum for which judgment is given. Or B, all or part of a sum in respect of which payment is made before judgment. And then in bracket 2, we talk about the date on which interest will start to be calculated. Interest under subsection 1 may be awarded A, for the sum for which judgment is given for all or part of the period beginning on the date when the cause of action arose and ending on the date of the judgment. And B, for a sum in respect of which payment is made before judgment for all or a part of the period beginning on the date when the cause of action arose and ending on the date of the payment. Bracket 3, in proceedings whenever instituted before the tribunal for the recovery of a debt, if the person from whom the debt is sought pays the whole debt to the person seeking the debt, otherwise than in compliance with the judgment in the proceedings, the defendant is liable to pay the plaintiff simple interest on all or a part of the debt for all or a part of the period beginning on the date when the cause of action arose and ending on the date of the payment. Bracket 4, interest under this section is to be calculated at a rate that the tribunal thinks fit. Bracket 5, interest in respect of a debt may not be awarded under this section for a period during which, for whatever reason, interest on the debt already runs. And then bracket 6, interest under this section may be calculated at different rates for different periods. Actually, 153A and B are the same as those HCO rules on the calculation of interest. Is that right? Yes, Chairman. We have modeled these on 48 and 49 of the HCO. Legal Advisor. Thank you, Chairman. I'd like to talk about 153 capital A. As the administration said, these are modeled on the HCO sections 48 and 49. And I can see that in the HCO, it is stated that these are provisions which are subject to the rules of court. But here in 153A, we do not have this rider that these would not be subject to rules of the tribunal. My question is, in the HC rules or rules of the High Court, is it that there are other provisions? And later on, under the rules of the tribunal, will there be provisions on interest? If there will be, then you will have to refer to those in 153A to say subject to rules of the tribunal, and then you can have 153A. Is that right? Mr. Wu, thank you for that view, Legal Advisor. This is a very valid point indeed. From what I know, the judiciary is now drafting rules of the tribunal under 158 of the Competition Ordinance. My understanding is that the judiciary has no particular intention to add in rates of interest in the rules of the tribunal. However, the judiciary would, where appropriate, would also mention court rules of the High Court in the rules of the tribunal. So for the sake of clarity, I will accept the legal advisor's view, and that is in 153A, we will add in a clause to say that these would also be subsumed under 158 of the competition ordinance. Okay, thank you. Then, Mr. Wu, can you carry on? Chairman, now we are at Clause 5, and we are at 153B. This is on judgment debts and how they would carry simple interest. 1. A judgment debt is to carry simple interest, and that is how it will be specified and the time of calculation. It says that it can be at a rate that the tribunal specifies by order, or in the absence of such an order, at the rate that the Chief Justice from time to time determines by order. And the interest under this section may be calculated at different rates for different periods. Also, under A, it will be the interest will carry on until the date the judgment or the payment is made. Okay, no questions. Please carry on. Clause 6. Clause 6 seeks to add 155A to the competition ordinance. This is modeled on Section 21E of HCO, so that the tribunal will be given the same powers as the CFI in terms of enforcement of payment of penalties and fines. Under the CO, there are sections saying that the tribunal should issue orders in order to make a judgment on penalties and fines. But then, in the CO, unlike the HCO, we have not included what liabilities there will be if people do not make payment. And we like to add in this new section so that the tribunal will be able to enforce payment, which are judged under the CO. And we are saying that there should be interest that will be payable. Bracket 1, the tribunal may enforce payment of a pecuniary penalty imposed under Section 93, and then a financial penalty imposed under Section 169, and also a fine imposed by the tribunal. And also under A and under A1, it says that the tribunal can impose other fines, and these other fines would, for example, be if there is a contempt of court and the tribunal would like to impose a fine. This will be one of these under 155A1C. Now, the enforcement will be made in the same manner in which a judgment by the court of first instance for the payment of money may be enforced. Bracket 2, if a penalty or fine described in subsection 1 is not paid in full when it is due, A, the tribunal may certify in writing to the registrar of the tribunal the sum payable, and B, the registrar is to enforce payment of the sum certified as a judgment debt due to the registrar. As the chairman said, this has been modeled upon Section 49 of the HCO. Any questions? Legal advisor. Yes, thank you, Chairman. With regard to 155A, actually I have written to the administration to ask for clarification. Under bracket 1, we have A, B, and C. Actually, I think they are written in a different way. A and B will specify the sections that have been contravened. A, Section 93, B, Section 169, but C, it doesn't refer to any sections of the ordinance. We'd like the administration to let members know which sections are actually referred to, or is this for a kind of underwriting purpose so as to include sections that are not mentioned. Perhaps we can look at the Chinese version. It is also a little peculiar. In A, B, and C, we only mention fines. But then in English, A is pecuniary penalty, B, financial penalty, and C, fine. But in Chinese, you use the same term, 罰款. And also, may I also draw your attention to C. In C, you talk about other fines, but in English, you only have a fine. Can the administration please clarify these points? Mr. Wu. Thank you, Chairman. Let me explain why 155A1C is a little general. As the legal advisor has pointed out, it is indeed a kind of underwriting provision. In other words, when the tribunal imposes other fines, it can do so under this mechanism. I cited an example, and we can, for example, expect to see a fine which is imposed on contempt of court, but we do not exclude other possibilities of fines. Now that we have this catch-all provision, we will have the mechanism in order to enforce payment. And the legal advisor has talked about differences in the drafting in Chinese and English. Can I defer to our draftsman? Ms. Law? Actually, all along, the term 罚款 in Chinese is the equivalent of fine, but in competition ordinance, there is a special situation. For pecuniary penalty and financial penalty, we also use the Chinese word for fine. If we look at A, we have some description before the word fine in Chinese, so we know where we should refer to. We know exactly what penalties we are talking about because we have the specification of Section 93 and Section 169. And we know that we are not just referring to fines in a general way. And then in C, we use the word fine to denote all other fines. However, if you look at A and B, the organization imposing the fine would also be the tribunal. And if we only include C, people would think that it is repetitive because C is general. And then people would think C can include A and B already, and A and B would be redundant. Actually, in the Chinese version, we think that this may be the question raised. That is why in C in Chinese we put in the word other fines, so that people would know that they are different from 1 and 2.
If I understand correctly, then the explanation is that C is a catch-all term, and under C it would not include A and B penalties, or penalties mentioned in A and B. If that is the case, then perhaps the administration can consider that in the English version, perhaps we can put in any other fine, even though I understand that for fine, it may be simply on the wording different from pecuniary penalty or financial penalty. But when people read the word fine, they would think that C would include already A and B. As for the Chinese, it is very clear. It says other penalties or other fines, and that is in its function, C in its function as a catch-all, and that is fine. Perhaps the English version can follow suit. Any other questions? No other questions. We can go on, Mr. Wu. Clause 7. Perhaps the judiciary can answer the question. Ms. Cheung, please. Yes, we are on Clause 7. Section 156, the existing one, is to be amended with registrar and other staff of tribunal. And basically, the temporary registrar, senior deputy registrar, and temporary senior deputy registrar, and the deputy registrar and the temporary deputy registrar is to be substituted to repeal senior deputy registrar and deputy registrar, because there are different rankings of registrar, senior deputy, etc. So to be clear, we just simply put them down as registrars, and basically by so doing we allow the more junior ranking members of the registrar to be able to dispose duties of higher levels of registrar. And by this method of drafting, we are able to have these registrar members dispose or to carry out their functions as intended. No questions. Clause 8, sections. Excuse me. Just on the Chinese 156A, perhaps when we come to clause by clause vetting at a later date will come up where we will discuss 156A Chinese version. Yes, on sections 156A to 156E, we are proposing to add after section 156 the jurisdiction and powers of registrar of tribunal. Well, actually, the registrar of the tribunal is a member of the tribunal. They will have the same status as the judges, but on the other hand, they may be less experienced than the judges, and they will be able to carry out work pertaining to more straightforward legal cases so as to take away the burden of work of the High Court and District Court and Court of Appeal judges. There are such arrangements in these courts as well, so as to lessen the burden of the judges. If we can go to, that is by way of background, let us now look at 156A, the jurisdiction powers of the registrar. In bracket 1 there, the registration of the tribunal, bracket A, has the same jurisdiction and privileges insofar as they are applicable to the business and proceedings of the tribunal as a registrar of the High Court, and may exercise the same powers and perform the same duties as a registrar of the High Court. The registrar of the High Court would actually automatically become the registrar of the tribunal. In fact, they may seem like two functions, but they are occupied by the same person. So the jurisdiction and powers of the two posts are similar. In bracket 2 there, bracket 2, similarly, the registrar of the tribunal has any other jurisdiction, privileges, powers and duties that may be conferred or imposed on him or her by or under the rules of the tribunal made under section 158 or any other law. As mentioned by the Bar Association just now, there are certain duties which cannot be carried out by the registrar but only by the judge. 156B bracket 2. If I may raise a Chinese version point. In Chinese, it says that a senior deputy registrar of the tribunal has the same jurisdiction privileges insofar as they are applicable to the business proceedings of the tribunal as a senior deputy registrar of the High Court, and may exercise the same powers and perform the same duties insofar as they are applicable to the business proceedings of the tribunal as a senior deputy registrar of the High Court. It seems, on reading, that there is a repetition of the same sentence. If we look at the Chinese version only, there would be this misunderstanding. But if we look at the English version, the corresponding part is by or under the rules of the tribunal made under section 158. By or under. Basically, the Chinese is segregating by and under, putting by and under into two different sentences. But in fact, it is not necessarily clear in the Chinese version. And if you look at the Chinese version further, after the comma, it says made subject to rules made under Section 158, and it goes on to repeat that again. But it is because there is a by and under distinction in the Chinese drafting. The second mention is under the rule of the tribunal. The former is by the rules of the tribunal. We looked at other ordinance in the drafting. For English, by and under. For Chinese, it would be 有或根據, with different corresponding Chinese terms to translate by and under. And therefore, for the Chinese version, it may cause confusion, or the reader may not be able to understand very easily the content if you adopt this form of drafting. Ms. Law? Yes, we have discussed this with the legal advisor. There are advantages to the existing Chinese way of drafting, so that we do not repeat the term 根據 in Chinese twice, but we will go back and further consider this again. Any questions? None? Ms. Zhang? 156B. This is corresponding to 156A, similar, but it is now referring to the senior deputy registrar. And in 3, it is referring to the deputy registrar of the tribunal. And they are similar in their duties as to those of the registrar of the tribunal. If there are no further questions, we go on to 156C. That is the temporary registrars of tribunal, their jurisdiction and powers. And it is very clearly set out here. The point to note is that these temporary registrars will have the same or similar powers and duties and privileges as full registrars. And 156D concerning the protection of registrar, etc., of tribunal. Simply put, if they have not made wrongful directions, and if there are any mistakes which are only in implementation only, if you can refer to 156D2 as an example, a person may not bring an action against a registrar or a senior deputy registrar, etc., for a direction given to the bailiff of the tribunal with regard to the execution or non-execution of process. Well, legal advisor, in fact, in the mention of a registrar, I see that there are discrepancies in the way it is mentioned. For 156D1, for instance, the different levels of registrars are mentioned. That is the registrar, the senior deputy registrar, the deputy registrar. But in certain clauses, only the registrar is mentioned, as we can see from 155A concerning the enforcement of penalties, bracket 2 there. And 2B, it mainly only refers to the registrar of the tribunal. Can perhaps the administration clarify why is that so? Perhaps the registrar of the tribunal, by mentioning him only or her only, you would have already included the senior deputy registrar or the deputy registrar? Or is it that the senior deputy registrar or the deputy registrar would also have the terms of reference and the powers and privileges of the registrar? I would like to know why under different clauses the ranks of the registrar are listed in full and some list only the registrar. Ms. Low. Thank you, Ms. Chair. In drafting, sometimes we would consider the length of the clause itself, it is not overly complicated, then we would choose to have all the persons or the titles mentioned so that the reader would know that this is applicable to whoever or whatever officers. Questions, members? None? Ms. Cheung. 156E. This is about the registrar, etc., of tribunal who may apply to tribunal for order through a procedure that there should be an application, there can be an application to the tribunal for order. Again, this harks back to the High Court ordinance. Questions, members? No. We come to Clause 9. The import of Clause 9 is to add Section 157A to the ordinance, and we refer to Clause 52 of the High Court ordinance for the drafting. And this is with regard to the reimbursement of witness expenses under the High Court ordinance. Under 157A, in any proceedings before the tribunal, member of the tribunal may order the reimbursement of a witness for any expenses reasonably and properly incurred by the witness by reason of his or her attendance at the proceedings. And in the procedures of competition deliberation, a witness may incur certain costs such as transport fees, etc., and in such cases, the person should be reimbursed. Members, questions? Legal advisor, Neil. Clause 10. This is to amend Section 158 of the ordinance. Basically, it is to add that prescribing the jurisdiction of the tribunal that the registrar, senior deputy registrar, or a deputy registrar of the tribunal may exercise, including provision for appeal against decisions made in the exercise of the jurisdiction. And basically, in Section 158(2)(d), that this Clause AA be included. And this referred to Clause 54 of the High Court ordinance as a blueprint for the drafting. So these, the registrar of the tribunal may, together with the senior deputy registrar or the deputy registrar of the tribunal, may exercise, including provision for appeal against decisions made in the exercise of the jurisdiction. In adding this AA clause, it amends 158A and B concerning the registrar, the senior deputy registrar, and deputy registrar of the tribunal and their terms of reference and powers. In the execution of the terms of reference, there can be further details, and we're looking at 152, 2, 3, and 4. Under 158E, we want to put in a paragraph F, which will give the registrar of the tribunal, after consultation, to set out certain guidelines to make order, the format of the orders to be given, prescribing the form of any order that the tribunal may make under this ordinance. And in making such orders in the future, the format is to be used, and such prescriptions are given this basis for so doing.
Please continue. Now we are at Clause 11. The purpose is to add in 158A, which is modeled on Section 57 of HCO. It allows the Chief Judge to make suitors' funds rules. Now, what are suitors' funds? A suitor is the party to any case, and because of different reasons, the suitors or parties may have to deposit monies with the court, including the future competition tribunal. 158A1 empowers the chief judge, who may, after consulting the president, make rules for regulating the following matters. For example, deposit, payment, delivery and transfer into and out of the tribunal of money, etc. And then in bracket 2, it says, without limiting subsection 1, rules made under that subsection may provide for the regulating the placing on and withdrawal of deposit of money, and also the interest on money placed on deposit, and also determining the smallest amount of money on deposit, etc. These are the technical arrangements. And then in bracket 3, we just want to state that securities, as a word here, includes shares. Any questions? Legal advisor? Thank you, Chairman. 2 points, please. 158A, 1B. We're aware that in Chinese and English, I think there is inconsistency. In B, second line, the investment of and other dealings with. In Chinese, it is 投資及作其他方式處理. Is it that there is inconsistency, please? Can the administration explain? And then second point, 1D. This is similar to what I asked just now. Here you only talk about the registrar, but actually this provision should also include the senior deputy registrar and deputy registrar. Is that right? Administration? Can I ask the draftsman to explain? Ms. Law? Thank you. 158 capital A 1B. In English we use the word and then in Chinese we use the word or. Now it seems there is an inconsistency. However, when we seek to interpret the provision, there will be no doubt in the meaning, because actually we are not talking about choosing one of the two. We are talking you can do either. Thank you. Legal advisor. What about D? You use the word registrar. Does it mean you also include the other two ranks? Ms. Zhang. The view of the legal advisor is correct. Under 158A, 1D, the word registrar does include senior deputy registrar and deputy registrar. Perhaps in the interpretation section, why don't you define this word? Because as the legal advisor said, sometimes you include more things, sometimes you don't. Why don't you state clearly in this bill that the word registrar, whenever it appears, would include the other two ranks? DS, we can consider this point, please, when we go back. Okay. Please continue, Mr. Wu. Thank you, Chairman. Now we go to part 3 of the bill. This is about amendments to other ordinances. Amendment to High Court Ordinance, amendment to Evidence Ordinance and Legal Practitioners Ordinance, etc. These amendments would just want the tribunal to be able to function more smoothly, and also the arrangements that now apply to CFI will also apply to the tribunal to be set up. Let me talk about Clause 12 of the bill. It seeks to amend Section 54 of HCO. In Section 113 of CO, it says that the procedures under the jurisdiction of the tribunal, if they are generated under the CFI, then they will be transferred to the CFI. And we have the details as to how the case would be heard at CFI, and the relevant rules would dictate how the cases can be transferred from one court to another. So we'd like to amend HCO so that under Section 55, the Rules Committee will be able to make rules about the transfer of cases between CFO and other tribunals. Any question? If not, the legal advisor, nothing. Then Clause 13, it seeks to amend Evidence Ordinance, Section 81. According to Section 81 of Evidence Ordinance, different officers and judges will be able to take a person in remand to any court in order to state a defense or to be interrogated as a witness. Right now, under the CO, the tribunal is not given this power. So we propose to make consequential amendments to Evidence Ordinance so that the Competition Tribunal would be given the same powers as other courts, so that people in a remand would be able to be taken to court to provide evidence. You talk about in remand, but this is only civil proceedings. Would this happen? Thank you, Chairman. But the person may be in remand for other offences. However, he may have to appear in the Competition Tribunal for civil proceedings. Because I don't want people to be liable criminally if they just commit an offence under the CO. Legal advisor. In fact, I have sought clarification with the administration already. Actually, in another bills committee at the LegCo now, and that is the Statutory Provisions Miscellaneous Amendments Bill 2014. It seeks to amend the Evidence Ordinance Section 81 as well. So it depends which bill would be passed first. If that bill goes first, then we may have to make consequential amendment to the clause here. Okay. Mr. Wu, please continue. Clause 14. It seeks to amend Section 39H of the Legal Practitioners Ordinance so that in the definition of higher rights of ordinance, we will add in the Competition Tribunal. Also, this is simple. Yes, it is. So the arrangements for the Competition Tribunal will have the same rights of ordinance for the higher courts. Yes, please continue. Clause 15, Chairman. It seeks to amend the higher rights of audience rules. Rule 2. In the definition, we add in the Competition Tribunal for the same reason that I stated for Clause 14. Why do you say AA? So it would precede the CFI, is that right? Why the Competition Tribunal should precede the CFI? Why AA? Why don't you just say E? Can I ask the draftsman to explain? If you look at the style of writing, C is the CFA. Okay, then you should put AA. I agree. Legal advisor, a drafting point in Chinese. If you look at the marked up copy, page 20 of the Chinese version, before A, B, C, D, you have a group of words. It says it means any courts or tribunals below. We are now adding in the Competition Tribunal. It is a court, all right, but in different ordinances, when we have additions or deletions, if what we are going to add may not be in the same group of the original existing entities, then it might have to be separately indicated. I already made the view known to the administration, and they would consider whether the word tribunal in Chinese should be added into the title. All right, okay. Please continue. Clause 16. It seeks to amend Schedule 2 of the Electronic Transactions Ordinance so we can add Competition Tribunal to Schedule 2. The objective of the Electronic Transactions Ordinance is to provide a legal framework for electronic transactions so that records of electronic transactions would have the same legal status as paper transactions. Because of technical constraints at the judiciary, now they cannot accept such electronic data, and that is why we need to amend or use the ordinance in order to exempt all courts and tribunals under the judiciary. But of course, the Competition Tribunal is not included, and therefore we have to amend the schedule in order to add in the tribunal. All right, any questions? Legal advisor. Yes, Chairman. A small drafting view. We're aware that if we look at the marked up copy, it will be easier. Page 21 of the Chinese and also the English version. On the right, you see paragraph CA, the Competition Tribunal established by the Competition Ordinance Cap 619.
Competition Ordinance.
As we see, now if we look at the Electronic Transactions Ordinance on the left-hand side, C, you say CGI, they say under the control of obscene and indecent articles, ordinance, etc. In other words, they talk about tribunals established under certain ordinances, but this time you use the word established by. Can the administration please explain why there is a difference? Ms. Law. This time around, we use the words established by because we referred to the competition ordinance itself and how the tribunal is defined. It says
tribunal established by section 134. 而中文呢就係由
in Chinese, it is a tribunal established under section 134. We have referred to that expression before we wrote this line. And another consideration is that when we put in competition tribunal in Schedule 2 of the ETO, whether we use established by or established under, we can achieve the policy objective. And we are aware that in Schedule 2, we don't only use the words established under. If we can look at ZN, it says the Deposit Protection Appeals Tribunal established under Cap 581. So established under may be the convention, but it is not the only way to do it. Legal advisor. Thank you, Chairman. It depends on what members think. Of course, I agree with Ms. Law that the present wording can achieve the policy objective. But as Ms. Law said, in the schedule, apart from ZN, you use the word established by. In all other constructions, they use established under. That is why in the list, it will look rather strange. Well, never mind. The administration can think about it. Please continue. Clause 17. It seeks to amend Schedule 4 of the Shenzhen Bay Port Hong Kong Port Area Ordinance. We'd like to add Competition Tribunal to Part 1 of the schedule. The Shenzhen Bay Port Hong Kong Port Area Ordinance has as one of the objectives to allow Hong Kong laws to apply to the Shenzhen Bay Port and also to provide jurisdiction to the courts of Hong Kong. As I said in Schedule 4, different courts of Hong Kong are included, but of course not the Competition Tribunal. The amendment is to add Competition Tribunal to Schedule 4 of the Shenzhen Bay Port Hong Kong Port Area Ordinance so that the jurisdiction and orders made by the Competition Tribunal can also be implemented in Shenzhen Bay Port. Thank you.
Now, we have come to the conclusion of this particular process. You will be bringing back, the administration will bringing back some of our opinions for consideration. Where there are responses, would you please circulate them? And if necessary, we will have a meeting on the 22nd of July for a further meeting if necessary. So please do go back and consider the points and work with the law drafters. I believe we have come to the conclusion of the clause-by-clause process. Some of the wording or technical amendments, we can make the changes by circulation. I do not believe there are major amendments as such. Well, thank you very much for coming. Thank you. End of meeting here.